Already in here.
You sure?
Ready to go.
Absolutely.
The mic's on.
I turn the mic on? Oh, it is on. Okay, good. Good evening, everyone. My name is Ronald Presner. I'm the chairman of the Zoning Board of Appeals for the town of Mount Pleasant. And I welcome you all to this evening's meeting. We seem to have a nice little crowd here tonight. Before we start the meeting, let me first introduce the members of my board. To my far right is Adrian Novak. To my immediate right is Mr. Nicholas DeChico. You can't hear me?
No, because your mic's
think
not
your
on.
mic's
Lenny,
not on.
your mic's not on.
How do I know the mic's on?
Because it's lit. It's not lit. Everybody else is lit.
Enjoy.
It's a little thank you for helping me. It's not mine.
Oh, that's your
It's 20 years ago. Really appreciate it.
Yeah.
Appreciate it.
Watch that. If I get in there, they'll have to get EMS to come and get me.
Testing. That works.
Is that working?
Mom, why don't you use this one?
It's on.
Gentlemen in the back, can you hear me now?
Because I hear an echo.
Okay. As I mentioned, Mr. Nicholas DeChico is to my immediate right. To my left is Kathy Niclario. She's the secretary of the zoning board. And to her left is Mr. Herb Doerr. And on the extreme left is Mr. George Lapatos. And sitting at the table diagonally in front of me is Mr. Joseph Briganti, who is the building inspector for the town of Mount Pleasant. So with that said, let me explain how we conduct our meeting. When the application is called, you'll come forward, I'll swear you in, you'll give me your name, address. I will read the application aloud for the public record, and then I'll ask a couple of questions, and you'll have an opportunity then to state your case as to why you need the variance. Once that's done, I'll ask if any members of our board have questions for you regarding your application. When that is complete, I will ask if anyone's here is either for or against the application. Once that's completed, the board will then decide whether to approve, deny, or maybe pass over until the next meeting that particular application. So with that said, the first application for tonight is Mr. Aldo Vitigliano. Okay. Testimony about to give the truth, the whole truth, so help you God.
Yes.
Okay. You are Aldo Vitigliano, you're the applicant.
I'm the applicant. My client is here, Stephen Cerise. He's the principal of Soldi Lane Associates.
Okay, and where is your office?
I'm at 150 Purchase Street in Rye, New York.
Okay. This is regarding Soldi Lane Associates LLC, owner of the premises located at 434 Sherman Avenue in Hawthorne, New York, correct?
It's the vacant lot behind 434
Yeah.
Sherman Avenue.
Designated on the tax assessment maps as 112.6-4-28, declaration that the vacant lot is a building lot for Town Code 218.3, lot, a parcel of land not divided by streets and having its principal frontage on the street or on other such means of access.
Correct.
Okay.
So I have a presentation I'd like to go through
Sure.
with some materials. There were materials that were uploaded for this, but I think I'm trying to create a record that will help explain this for it. So the first thing that I'd like to do is to give the board a history of the property as it relates to the specific deeds and how ownership came to pass. So there's 6 copies of all this. So you will pass it down?
Sure.
Okay. That's great. very simply, house, I believe, was built in or around 1932. There's an application for a permit for a garage in 1932. It was acquired in 1946 by Mr. and Mrs. Litchauer for it. In 48, they purchased one of the lots up on Warren from the town of Mount Pleasant. In 51, they purchased another lot from the town of Mount Pleasant. Mount Pleasant had acquired them by way of an in-rem foreclosure. As the board is well aware, this is part of what we call the Smadback properties subdivision going back to the 1892, where the town was divided up, this portion of the town was divided up into 25 by 100 lots. People would come up on the railroad, buy a lot for it, eventually build on some of them. All these lots get transferred into one deed in 1962, okay? Jelinek, it gets conveyed from Litchauer to Jelinek. This is all what I've provided for it. The properties have always maintained two separate tax bills for as long as I'm aware of, one for the Sherman Avenue side and another one for the Warren Avenue side. So from town purposes, the two on Warren Avenue were merged into one tax bill for it, and Sherman Avenue always maintained a separate tax bill. So these lots were eventually conveyed by a series of other deeds, Celiano to Bone, Bone gave her interest to Celiano, and Celiano to Zaczynski, and Zaczynski to a trust, and then the trust conveyed in 2024 by separate deed to my client at 434 Sherman, but also the Soldy Lane Associates. So we're filing this application on behalf of Soldy Lane Associates for the Warren Avenue side for it. But for the record, I only have one copy of this, but I do have copies of all the deeds that can, in case there was a need to look at what I just referred to.
It's just one, sir, it's just one page? Sir? It's just one page for each person, or is there multiple pages for each person?
No, this is one set, so this
Oh,
is
one.
just, that really should go to Kathy if you want to look at all the deeds
One set.
that are referred to. That is one set,
Okay, very good.
okay? Okay. So the next thing that I have is a survey of the property currently, as well as a survey from 1962. The 1962 survey was part of the record that the town had maintained, but we have separate 2 pages, 6 sets, I believe. I'm sure that the board has visited the property, but I'm including one set of photographs, just for the record. Then we have 6 sets of the municipal records for this property, for the property on Sherman Avenue, just to show that there was a garage permit in 1932. There was a permit for replacement of the garage later on in 1955. And then there's reference to the Jaczynski application before the zoning board. So again, 6 sets, they're all clipped. So with this information for it, we're here to present our case. We had looked at the possibility as to whether this fell under the category in the town code for undersized lots. There is a provision that was put into the code, I think in 1969, to address the fact that some people had accumulated lots that were less than current zoning for it. This is in an R10 zone for it. And so something was added to the code. We are not coming before you on that provision because the property was in common ownership, even though it was separate deeds, for a long time for it, and separate tax lots. But we just pointed out just to avoid any confusion. It's kind of a confusing statute, but we're here on the basis of that we believe that the Warren Avenue lot is what we call a back-to-back split. The concept of back-to-back split is something that came about in the late 80s, where the courts recognized that where you had these types of properties, where people had lots that were street to street, okay, that there was a need for some relief to be granted, because otherwise there were parcels that didn't necessarily comply with the area requirements of the zoning ordinance, and so therefore people would be left with property that didn't fit into the neighborhood. Typically you have houses backyard to backyard, the front yard is on a street, such as what the entire area was designed to be. The entire subdivision going back to the 1890s was streets running by with lots back to back, so to speak. So the concept of back-to-back split is something that emerged in courts from cases. And there are certain requirements for them, okay, which basically is you have to have frontage on separate streets, meet the depth characteristics of the area as it has developed. And the purpose of showing the surveys is to show that the Warren Avenue lot has 100-foot depth, which is what's required by the code for it. And then they're never used in conjunction with each other. And we maintain that the use that may have occurred over the years is very casual for it in terms of that there was no interaction really between the two lots. I understand, and I've read something that was put in by an adjoining neighbor relative to the fact that there was a fire pit, there was a shed at one point in time for it, but we believe that to be casual, it wasn't required. We think the intent of the property owner is important. For it in 1955, even though they had the ownership of the other two parcels, they took out a permit to replace the existing garage on the 431st Sherman lot. They could have pushed it back if they wanted to onto the other property they had required, so obviously there was an intent to maintain the separate nature of what's there. If you look at the configuration on the survey, it's going to be very difficult to do anything other than what we're proposing, that the Warren Avenue side be allowed to be developed as a lot. While you have area and you could build a bigger home, you theoretically probably wouldn't even meet the side yard setback requirement, because the property on Sherman Avenue is a narrow lot in conformance with other properties there, but the rear portion is much wider for it. So you'd have to almost have like a breezeway to get to any further development, and that would look totally odd if it was to be developed in that fashion with some larger residence on it. So we're here to answer some questions. There is some case law that we can kick up for it. There's also precedent of this board in terms of recognizing back-to-back splits, that with back-to-back splits we don't, that's one of each, back-to-back splits we don't really need anything from it. We're here to basically ask for a declaration just to avoid any confusion for it. And I'm handing up a record in the case of Cervillo, which was 345 Linda Avenue. Where basically with a back-to-back split, it was indicated we didn't even have to, the zoning board had nothing to do. They had no jurisdiction in connection with a back-to-back split. So that's pretty much our presentation. I'm sure there will be some questions, which we're here to answer, or you can hear from any of the neighbors first. I understand that at least one neighbor on Sherman Avenue wrote a letter, I believe, to the zoning board indicating they have no opposition.
What's that?
Do you have that letter written? for that?
I know, I remember seeing that letter. They were in favor, I believe, of the application.
They're on the other side of the street, though.
I don't have that with me. There was a letter from
Joe.
one of the neighbors
Correct.
showing that their approval
Correct.
for this lot.
Yes, the name for the record. What was Joseph?
Okay, this is going back.
We're on this case, right?
Was that?
We're on this.
I go back even further than that. One of the concerns, I know it's outside the jurisdiction of the ZBA, but when we did our inspection of the property, it was,
Still can't hear.
I can't hear you talking a little
Oh.
bit better.
Mike's modern engineering. When we went on Saturday, we took a look at the property, both properties. It's fine. One of the things I noticed is probably from the street, this is the one on Warren Avenue, it goes in about maybe 20, maximum 30 feet, and then there's a sheer drop from there.
Correct.
Okay. So I know it doesn't fall within our purview, but that's a steep slope. You have to go have some sort of
Correct.
verification on the steep slopes.
Correct.
That's a tough piece of property to build on, you know.
It's a tough piece of property, but it's in keeping with, the neighborhood.
Oh, no, I'm not
The whole
disagreeing.
neighborhood is up on a hill, and
If you go to Linda Avenue, another spot there, you got houses with no backyard, and they got a mountain behind them.
right.
And on the other side, it's like Pasadena, California. I have no questions. Ms. Novak, do you have any questions for the
I don't have any
applicant?
specific questions at this time. I would like to hear if there's anyone for or against, and I may have some questions after that.
We'll see. Mr. DeChico?
Not at this time.
Mr. Dorr?
Not until after public comment.
Mr. Lepatos?
Just one question. Mr. Vitigliano, when I was looking at the application, and I was looking at the case that you cited, the Moran versus Irvington ZBA,
Yes.
I noticed the Irvington matter was an area variance that was improvidently denied by the board. This application is designated as a declaration.
Correct.
Is that one of the specific permissible functions of a zoning board? I thought it might be more of an interpretation, which is specifically permitted. I wasn't really sure.
I think it's a question of semantics for it. There's no ruling of the building inspector for it. We had asked the building inspector for a ruling. It was kicked to town attorney, and it was kind of like, you know what, just go to the zoning board. So we didn't necessarily have our ticket punched, okay? And that's how I characterize it. But
But what-
to me, it's semantics for it.
Would it fit within the authority of the board pursuant to an interpretation, or would that not be consistent with what you're representing?
It fits within the authority of the board, but the board may not even have jurisdiction to hear it if it's a straight back-to-back split. So somebody has to rule that it's a back-to-back split. Either your board has to say, hey, it's not a back-to-back split, so come before us and building inspector, give a denial and, or whatever. So we're trying to get to where we have to be, which is for a determination, is it a lot, is it not a lot?
Okay.
Well, I understand what you're saying. trying to work through it, but it would seem to me that the more regular process would have been to get a decision from the building department saying that this is not a back-to-back split, and then you would come to us to challenge that interpretation. That would have been the more normal course of business, perhaps?
Theoretically,
Theoretically.
for it. I mean,
But that's not what, we're on a slightly different track here.
we're on a slightly different track.
Okay, very good.
All right, any other
And
questions?
we're not trying to game the system in terms of that. This was kicked to town attorney, and
That wasn't my suggestion.
That's fine.
I
No,
just-
no,
I'm
no,
trying to
nor mine.
clarify.
that's fine.
Nor mine.
Okay. Are there any other questions from the members of the board? No? Is anyone here for or against this application?
To speak.
One of you, come up, please.
I prepared something.
Yeah,
Right.
just the microphone. Just take that, you can have a seat if you like.
You have to swear you in.
Right, before you start, let me swear you in. Testimony about to give is the whole truth, nothing but the truth, so help you God.
I do.
And your name?
My name is Paul Rubio.
Paul Rubio. Where do you live, Mr. Rubio?
I reside in Ulster County. My mother, Helen Rubio, is here, who owns 438 Sherman Avenue, and I'm a trustee to that
Okay.
property.
Which,
All right.
438?
438, yeah, on Sherman. So, I prepared some materials for you. Do you have the materials I prepared?
Pass.
Okay. Can I just say before I read what I'm going to read, because I'm not an attorney and I'm just preparing what I could here, and you understand that, I know. There's some attachments, and I'd like you to take a minute to look at those attachments. They start as Figure A, and they can certainly be provided to the attorney. I'm not disputing anything. You're welcome to do that. But I wanted you to look at them first before I read, so that you have some information as a point of reference. Okay. Those are just some aerial photographs and some local photographs of the property. Also, there's the square footage of the lot, of both the lots, Lot 28 and 434. That I could find with my research, so I included them. So let me read, and I do appreciate the opportunity to come and respond to the application. So I'm going to read what I have to do here. My name is Paul Rubio. I'm here to formally respond to the arguments raised in the letter from the attorney representing Saul D. Lane Associates. As the son of Helen Rubio, who resides at 438, directly adjacent to Lot 28, I'm the trustee of that property, and I strongly oppose the assertion that this parcel is buildable by as of right. So let me continue. I'd like to respond to the claims in his letter, the attorney's letter dated March 17th, 2025. First, the attorney for the applicant asserts that Lot 28, quote, retained its attributes of a separate building lot, i.e. ownership by way of separate deeds at 1958, retention of separate parcels over the years, end quote. He also asserts that Lot 28 has maintained its character as a single-family building lot. These claims are both legally and factually incorrect. Again, this is my perspective. Lot 28 has never functioned as a separate building lot. For decades, it has been and continues to be held in common ownership with 434 Sherman Avenue, Lot 34, and used as a spacious backyard. There's no fencing, no history of independent use, no indication it was ever treated as anything other than an extension of 434 Sherman. In fact, the rear third of Lot 28, approximately 2,300 square feet, shares the same elevation as 434. Until the sale of both properties to the applicant in 2024, it included a tool shed, fire pit, picnic tables, seasonal storage. These are all signs of long-standing active residential use, confirming it as an integral part of the property at 434. While it may have retained the separate deed or tax parcel, these administrative distinctions don't override what I believe to be the zoning code. The attorney asserts, in essence, it's half of a back-to-back split, whereby each lot retains the status of a separate building lot. Despite its general historical understanding, the term back-to-back split doesn't appear to be anywhere in the Mount Pleasant zoning code. The concept is not codified as a zoning right. It's an informal term with no legal force, thereby always open to interpretation. Even if one is to accept the general understanding of back-to-back split, that designation depends upon the practical and functional separation of the two lots, even when they are held in common. There's no evidence that Lot 28 was ever treated separately from 434 Sherman. In fact, quite the opposite. There's no fence between the properties, no driveway access from Warren, no history of separate use, lease, or address. Lot 28 abuts 434 Sherman at the exact same topographical level and has been used continuously as a continuous functional backyard for over 60 years. The attorney for the applicant asserts that Lot 28 was held as a separate parcel since 1958, entitling it to treatment under Section 21879. I believe the attorney is correct in that, in this circumstance, Lot 28 is subject to consideration under 2817, but only insofar as 2879, is made invalid by subsection A, which controls this situation. In fact, by operation of law since 1958, Lot 28 and Lot 434 have been merged. To summarize that provision, lots that are undersized and under common ownership at the time the zoning ordinance was enacted in 58 are automatically merged and must be treated as a single conforming parcel. This language means that merger occurs by operation of law. No filing of deed or merger is necessary. The fact of common ownership in 58 combines with non-conforming undersized status creates the merger, and thus the Lot 28 ceased to exist as a separate building lot at the time. Any argument that it retained independent status misrepresents the law and ignores both the statute's language and its intent. To prevent workarounds that exploit its intent to prevent workarounds that exploit historical lot lines for new development on substandard parcels. The applicant's attorney also refers to a series of legal cases, Guazo versus Chavez, but these cases are not relevant, in my mind, in this case. When 21879A was adopted in 1958, Lot 28 and 434 were, by operation of law, merged. Cases dealing with general zoning interpretations don't negate or supersede the specific merger provisions codified in 2817A, which explicitly mandate merger when substandard lots are adjacent and owned by the same person. Again, 21879A mandates that contiguous commonly owned substandard lots must be combined. It's binding law, even if you accept Guazo as a persuasive authority. It applies only where merger conditions are not met. In this case, conditions are met. The applicant's attorney cites case 0753, in which the board allowed development on a parcel described as a back-to-back split to support the claim that Lot 28 qualifies similarly as a buildable lot. However, this case is not applicable to the case before the board for the following reasons. There's ample evidence that Lot 28 was under no understanding. There is ample evidence that Lot 28 was under no understanding of the term a back-to-back split. In fact, it was legally and functionally merged with 434 since 1958. As stated above, the rear third of the lot has for decades been the use of a continuous backyard at the same elevation. My mother, who has lived there for the past 47 years, can attest to that. Moreover, case 07-53 didn't involve lots that were merged by operation under law, under a law such as 21879A. The attorney states, due to the topography of the lots, it's impractical for the subject parcel to contribute to the value of the utility of parcel 434. The facts overwhelmingly refute this claim. As stated before, the rear third of Lot 28, 2,300 square feet of which rises no more than 3 feet above the easterly contiguous border with 434. Up until the sale of both properties, it included a tool shed, fire pit, picnic tables, and seasonal storage. Its utility is self-evident, as it has served as a backyard for 434 under common ownership for at least 60 years. And since Lot 28 and 434 were merged by operation of law in 1958 under 2879A, this large 2,300 square foot backyard has quite obviously contributed to the significant value of the combined lots. Finally, the attorney states the adjoining neighbor to the north has a lot similarly situated, and upon information we believe has been in separate deeds since '58. The attorney is referring to Lot 27. This lot is contiguous with my mother, Helen Rubio's 438 Sherman Avenue, Lot 35. That lot has frontage along Warren Avenue, has the same topographical layout, and just like with Lot 28, the rear of Lot 27 abuts my mother's parcel, and 1/3 of it serves as my mother's backyard. However, unlike Lot 28, Lot 27 and 438 have existed under one deed and were subject to the merger as mandated under 21879A. The town has already applied this principle to Lot 27 and 438. Lot 28 is no different and must be treated consistently. Granted, different treatment of Lot 28 would not only undermine the intent of the code, it would invite claims of arbitrary and unequal enforcement. In conclusion, Lot 28 is not and cannot be a building lot as of right. This determination is not a matter of interpretation, it's a matter of law. 2879A clearly and unequivocally merged those two lots in 1958 by operation of law. That merger wasn't discretionary and subject to change of a sale or tax map number. No subsequent sale or tax map number can undo it. The applicant's repeated use of non-legal terminology such as back-to-back split and citation of inapplicable case law does not establish a legal right to build. It attempts to sidestep the clear intent of the language of the Mount Pleasant zoning code. The law is clear, the facts are documented. Precedent, including the treatment of Lot 27, is established. I respectfully urge the zoning board to reject this application and uphold the integrity of Mount Pleasant zoning law. Thank you for being patient enough to let me read the letter.
All right,
I appreciate
just
that.
quickly, a little mouthful there.
Thank you. Do you have any questions for me?
Yeah, I have one
Okay.
point. On Lot 28, the portions of Lot 28 were used for, let me rephrase it. 434 Sherman used part of Lot 28 over the years as a part of their property, their everyday property, let's put it that way.
Yes.
All right, so if they had a tool shed over there, or they have barbecue grills or anything else, it's been used that way since the beginning.
Right.
Is there anyone else here has a, ma'am?
Oh,
You're, what?
Do you have a question? Do you want to ask a question?
Mr.
I'm
Chairman,
sorry.
Are we all going to be able to?
Yeah, let's do
I'm
that.
happy to answer
Well,
any.
I don't want to jump ahead,
Adrian?
but I
Well, let's start over. Adrian, do you?
Not
have
at
a
this
que-
time.
Okay. Do you have a question, Nick?
No, sir.
Okay. Herb? George? Oh.
just with regard to the factual claims that you made regarding the use of the property for various purposes, a shed, fire pit, picnic table, and the like.
Right.
I know in a general sense you've asserted that. Do you have any additional information, such as the frequency of its use, how long those additions to the property were present? You indicated there was a shed at one time. Do you know when the shed was there, when it was removed? I mean, just some things to give us some color other than claims that there were 4 things on the property at some point over the last 60 years. Not to say that that's not accurate.
Right, I
but
understand
I was
that.
hoping-
Yeah, no, I understand that, given the fact that you're sitting here looking at the documents, trying to make a judgment about this. I can defer to my mother, who has lived there for 47 years.
I don't want to impose on anyone to
Right.
be in an
Right.
uncomfortable position.
Right.
I was just asking if you had some additional information that you could offer. If you're not able, that's
You know, I
fine.
didn't have time to look through all of our family photos of all the parties and things we had at my mother's house, where we could clearly see what was going on next door and what was happening next door, nor did I have time to document my own experience being there and witnessing people using the backyard there. So I'm sorry that I couldn't do that. I understand and appreciate the question, though.
I can tell you when the shed came down.
I don't want to have to swear your mother in. Maybe you
That's
wanna
all right,
confer with
that's all
her?
right.
I won't be upset if I have to.
Do you want to confer with her and then come back to the mic?
Are you asking for proof that other than the aerial photograph, which was taken in 2014, I believe, that usage, proof that that was happening for the past 60 years, that was a backyard and it was in use for the past 60 years?
I don't want the words in your mouth. I'm asking, how long was it used in each one of the ways to the best of your recollection? Was it used, did it have a shed on it for 60 years? And maybe it did, or maybe it didn't, but I don't want to assume anything.
I cannot
So-
tell you precisely how long those
Okay.
things have been on that property for that long. The reason I responded to it in the letter is because the letter states that clearly it was no utility, that property, Lot 28, had no utility to 434 whatsoever. And that's an obvious misconception in my part, or misrepresentation. So that's why I said, that's not true. It's been used as a backyard. It's had utility and value. Depends on how you rate value, actually define value. So simply stated, I was responding to what the attorney put in his letter about the utility. I took particular note of that because had no value, no utility or value. That is just not true. I'm sorry. That's my
There's nothing
contention.
to be sorry about. I was just trying to get
All
as
right.
much detail as I
Yeah,
could.
that one really
And
hit me,
I
'cause I was-
understand
yeah, all right.
everything you've said. Thank you.
All right, sorry. I'm sorry. Is there anything else anyone would like to?
Are there any other questions from the members of the board?
To the common observer,
Yeah.
if somebody didn't know anything about these properties or lot lines or anything like that, in your view, to the reasonable person, common observer, if they walked to their property, how would they deem that area right behind the structure of 434? What would the common observer
The
feel it was?
backyard.
Okay.
The backyard. It's the same level. I mean, you can look at the map that I gave you at contour lines. It's about 3-foot difference. So it's groomed, it's got grass, it's had grass, right up to the outcropping and over to my mother's bushes. So yes, and if you walk to the back of that house, it looks like it's the backyard. In fact, anyone seeking to purchase the property which is for sale right now would assume, unless they read the documentation, that it was the backyard, or that it is the backyard currently. And I believe that. I took an oath. I believe that to be true.
Okay,
Thank you.
thank you. I had one other person who wanted to speak. Good evening. Raise your right hand, please. Testimony you're about to give is the truth, the whole truth, so help you God.
Yes.
Your name?
Tammy Steffen.
Excuse me?
Tammy Steffen,
And where do you live?
412 Warren Avenue.
Okay.
All right. Hello, Chairman Presner and members of the zoning board. My
Can we
name's-
talk? I'm sorry.
Closer?
Even though I have my hearing aids, it's hard to hear what you're saying. If
Okay.
you talk a little louder.
My name's Tammy Steffen, and I live directly across Warren Avenue from the property under consideration today. I'm here to express my strong opposition to Saldy Lane Associates' application to build on Lot 28. As a longtime resident who has observed this property for years, I can confirm that Lot 28 has always functioned as the backyard of 434 Sherman Avenue. I've seen the tool shed, fire pit, and picnic tables that were there until recently. There was never any suggestion that this was a separate buildable lot until the current developer purchased both properties. I'm not a legal expert, but I understand that our town's zoning code is extremely clear on this matter. Sorry, I need water. I forgot it.
Just relax. We only kill people on Tuesdays. This is Thursday night, pizza night. Okay?
Okay. Section 21879A states that when undersized lots were under common ownership in 1958, they shall be combined into a single parcel. This isn't optional or subject to interpretation, it's mandatory. This provision exists for good reason, to prevent exactly this type of attempt to exploit old lot lines to build on substandard parcels. Allowing this development would undermine the minimum lot size requirements that protect the character of our neighborhood. I'm particularly concerned about the precedent this would set. The developer's reliance on the undefined concept of a back-to-back split, a term that doesn't appear anywhere in our zoning code, seems like an attempt to circumvent clear rules that have protected our community for decades. What's especially telling is that the lot to the north, Lot 27, which is in an identical situation, has been treated as merged with 438 Sherman Avenue. Consistency in applying our zoning laws is essential for maintaining public trust. Our zoning code was carefully crafted to preserve the character and quality of Mount Pleasant's neighborhoods. I respectfully urge you to uphold these standards by denying this application, which clearly conflicts with both the letter and spirit of Section 21879A. Thank you for your consideration.
Thank you. Gentlemen all in the back? The agenda. Okay. Raise your right hand. Testimony you're about to give is the truth, so help you God.
Yes.
Thank you. Your name?
My name's Kevin Hopkins. I live at 405 Warren Avenue. I'm right next to the lot. I just had
If I'm facing that lot, are you to the left or the right?
if on the street on Warren Avenue, I'm to the right.
Okay.
I just had, actually I was gonna have a few questions, but just a couple of the comments. One is that was used as a yard. I live next door to it. I'm actually looking down on it. They always were out in the yard, you know, entertaining, hanging out, so that's true. The other thing is, from one of the earlier comments, is that, you know, the attorney said they probably kept it for the purpose of selling it at some point. The reality is, if you live behind it, next to it, the other side, my other neighbors are here, it's a tree-filled lot, so people like that. You have a lot of privacy in the summer, so I would imagine the people that live below it were looking up at a nice lot full of trees as opposed to a house was beneficial, and that's probably why it was never built on for years. But I just had, like, question two is, what is the size of the lot versus the standard size? Like when you say a small lot?
It's in an R10 zone, which means 10,000 square foot lot.
Oh, okay.
This lot is 5,000 square, so we call that, it's a, it's a, what do you call it? It's not a regular lot. It's a
Oh, it's half?
substandard lot.
So it's half the standard?
Yeah, it has everything to do with size, nothing to do with quality.
Okay.
Just that is, for that 10,000 square foot area, it's a substandard lot. It's below, if you had 9,999.9 feet, it still would be substandard because it's not 10,000 square feet.
All right, thank you for that.
Okay.
And I haven't seen the design, like how far is it from the other houses? Is everything else within standard or any other variations? Or
Well, it's a standard lot.
the building, the house, driveway?
It's out of our purview.
Okay.
Right, that's a planning board. There's a lot of issues with
Oh.
steep slopes and everything else.
Right,
What we're concerned about with the zone, we follow State Law 267B, and it said, is it self-created? 99% of the time, it's self-created.
okay.
Does it have an effect on a community?
Right,
The neighbors in the community? It may. We don't know. Are there other means? Maybe.
right.
Right. So what we try to do is come to some sort of a decision. And with this application, I don't know about the other board members, but there's a lot to swallow here.
Yeah, I just had, so one of the concerns with it being trees, we're lucky on our street that we don't have the flooding some other people have sometimes, because it's basically a lot full of trees. So is that something the planning board would ask the review, or it comes under you?
You're also on a hill, so water goes in one direction, and that's down.
Right,
So you don't have if you have any kind of a problem, it would be water coming through, down
well,
to
it gets
towards.
absorbed.
Yeah.
Right,
So what I would say to you, sir, is that the issues that you're bringing up are certainly important and relevant, and I would be concerned about those too, but the board's role tonight is just to decide whether or not really anything could even be built there in the first place, and then if, depending on how we decide that, then once there's an actual plan as to what actually wants to
Oh.
get built there, that would be determined.
Okay, I
later.
just, thank you
Yeah,
for
we're-
that. Yeah, I was just.
They're all relevant issues, just really a
Yeah.
little bit ahead of the game for where we
Okay,
are tonight.
all right, yeah, but it was a yard. I know
Last
that
one,
much.
anyone else
understand.
wish
Thank
to
you.
speak tonight?
Thank you.
What the hell is that?
That's you, right?
Shut me off, thanks. The members of the board, there's a lot to take in for tonight. And my opinion is, at this time, I'd like to adjourn this meeting until
Mr.
next month.
Chairman, can I make a suggestion? That
Yes.
we just hear from the attorney again to
Yeah, I'm
rebut
sorry.
anything.
Sure.
Thank you. I just want to correct the record. On the survey that we provided, there is a notation that Ward Carpenter calculated the area of the lot on Warren Avenue to be 8,131 square
How much?
feet. 8,131 square feet, not 5,000. There's a little notation down here, so just to correct the record. If there are any questions, I'm sensing you want to adjourn it for it. If there's anything you need from us, please indicate.
I'm just curious if you have any, not that you have to at this time, but if you have any specific responses to the gentleman, Mr. Rubio, regarding use or merger by operation of law. If you're prepared to respond to any of that tonight.
I mean, this section in the code is there. We're not refuting that. If I mischaracterized anything in my initial letter, closer detail, I've provided the detail tonight. I think the concept of back-to-back slip, while not in the zoning code, it's been recognized by this board. That's precedent, that's important, but it basically comes out of state courts saying that when you have this type of development, it makes sense for there to be back-to-back development and back-to-back splits to be permitted. And we're not disagreeing with the casual use, but that's what we're kind of calling it. A fire pit. There is no indication that the shed was legal. There's no permit that's filed. I've given you the municipal record in terms of that. So if it was a shed and it was an illegal structure, okay, for it, that's another factor for this board to consider. But a picnic table can certainly be moved for it. And quite honestly, the neighbor next door may be in the same situation where they can have a back-to-back split. I get the sense that they may have been denied at one point in time. I don't know if that's accurate or not for it, but I believe they're in the same situation where they have the potential to develop their property with a back-to-back split if they chose to. Okay. Any other questions or?
What would the board like to do at this moment regarding this application?
Mr. Chairman, I would move that we close the public hearing and adjourn for decision only, unless there is another application to just continue the public hearing on the next date. But that is not my application at this time.
I'm comfortable closing the public comment.
Yeah.
Okay.
There's no additional parties that wish to address the board, and we can adjourn for decision.
We can do this here.
I'm not,
And then we
Mr.
wouldn't-
Chairman, I'm not prepared to make a decision tonight. I would like to review, and then if we close for decision only, we could come back and state on the record more thoroughly why or why not we are making the decision we're doing.
Well, my personal feeling is that there's a lot here that are presented, both by Mr. Vitigliano and also by Mr. Rubio and two other people here before us. And for the board to make a decision at this time, I don't think it justifies. We should sit and discuss this and absorb what we have here. There's a lot to absorb, and then take it up at the next month's meeting.
It certainly can be put over. If the public hearing is closed and we adjourn for decision only, we can discuss in a business session at the next meeting. As we know, our business sessions are conducted from the dais.
I know.
So people can listen.
I have a question. Is it all right if I ask a question?
Yes?
Relative to what you're saying. If you vote to close the public hearing, could you provide the opportunity for, and you don't make a decision right now, can you provide the opportunity there's new information that I did not have from that letter, that was presented this evening.
Mr. Chairman, you can give a time frame for the submission of additional materials.
Yeah, well, you have a month, because if we adjourn this,
Give me a specific date by which submissions need to be.
Well-
Send it to me.
well, let,
That's what you would
talk,
Let's give a time.
yeah, talk to Mrs. Niclario. Call her and she'll make the arrangements as far as timing is concerned.
Right, I just, this,
Well, you guys decide.
we closed public comment, I just want to make sure everything's possible.
I understand.
May 1st.
Yeah, there's a lot here.
Mr. Chairman, I think, noting the nature of the application, a timeline for the public to submit would be helpful, which would then give the applicant less time to respond as well.
George is saying by May 1st, so you have time to
I agree
review
with
it
May
before
1st,
the
that's what I was
meeting,
thinking as
And
well.
then it goes to me and I send it to you guys.
Gives us time to review and
Yeah.
absorb and
Yeah, so,
be ready to further
So written
discuss.
comments to me by May 1st.
so let them make the comments. You said May 1st?
Yeah.
All right, so the comments should come to Ms. Clario by May 1st, and then it'll give the board an opportunity to,
So, Mr.
Absorb it.
Chairman, I'll formally move to, again, close the public hearing for decision only with further submissions to be allowed by May 1st by any party that wishes to do so.
I'll second.
second by Ms. Novak. Mr. Dorr?
Approved.
Mr. Lepatos?
Aye.
Chairman says aye. All right, so we'll hold off until next month. All right. The next application is Joseph and Veronica Costanza.
Lost track of my own conflict.
These are the only comments.
John, thank you.
Raise your right hand. Testimony you're about to give is the truth, so help you God. You're Joseph Costanza?
Yes, I am.
And you're the owner of the premises located at 8 Forster Place in Pleasantville, New York?
Yes.
On the tax map, it's designated as 106.8-2-6, and the application is for a proposed 6-foot-high fence on the right side
Correct.
of the property on a legal standard 16,000 plus square foot, a lot in the R10 zone. 4 foot is the maximum fence height, you wanted 6. We're looking for a 2-foot variance.
Correct. I'm looking to put up a 5-foot vinyl fence with a 1-foot lattice.
Yeah. I think we had a picture of that when we did the inspections.
Yeah, he changed the
Um,
color.
I don't have that in front of me, but,
Yeah, he has, you have that paper to show them with it? He changed the color, so he has a new one.
no.
Is the wood one with the spindles was $27 more, so now he just went with plain like this. So he changed.
This would be this fence here.
Okay, so it's an off-white, like a grayish
It's
color.
going to be cedar. The color will be
Mr. Chair, I just want to make sure we're getting all the comments on the record.
Yeah,
Just so you just got to speak up.
Harry. All right.
But I think the point is, sir, that regardless of the color or specific style, is that the first 5 feet from the ground would be of a solid.
It will be solid, and then 1
the
foot.
top 1 foot would be of a lattice type
Correct.
design.
Okay.
Correct.
And that will be the the joint property line on
The length
on the
of
right side of
right
your
side of the
property?
property, approximately 170 feet.
Okay. Ms. Novak, you have any questions? What's that? You all right? Ms. Novak, you got any questions?
We were out there on Saturday. I don't have any questions.
Okay. Mr. DeChico?
No questions.
All right, Mr. Dorr?
It was pretty straightforward, just replacing an existing fence to begin with.
And I have nothing, Mr. Chairman.
All right.
Thank you.
Is there anyone here for or against this application? No? Yes? You are?
Do you wish to
You have
speak?
You wish to speak?
Okay.
Mr. Chairman, based on no for or against comments from the public, and it's replacing an existing fence, I vote to approve approve as submitted.
Do I have it? Second by Mr. DeChico. Ms. Novak?
Aye.
Mr. Lapatos?
Aye.
Chairman votes aye, carried 5-0.
Thank you very
Good
much.
luck to you. Next application, 25-7, Timothy Shoddy. Did I pronounce it correct? Raise your right hand. Testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I swear.
Okay. And you are Timothy did I pronounce it right? Shoddy?
Yeah, Shaddy.
Shoddy, okay. You're the owner of the premises located at 201 Madison Avenue in Valhalla, correct?
Yes.
And it's designated on the tax map as 117.15-3-53. And the application is for a proposed construction of a new pergola attached to a single-family dwelling on a 7,500 square foot lot in the R10 zone. Side yard setback 12 is required, existing is 9, proposing 9, in 2.9 foot variance for what you're asking for. And on the rear yard, 30 feet required, existing is 27, and your variance is 3 feet. And the reason that those variances are there, because you have like a patio,
Yes.
a
There's
portico,
pre-existing.
like a
concrete
deck,
patio
like a deck. You have a deck there. And what you're going to do is cover the deck with this portico.
there. Yes.
Okay.
Full coverage of that deck.
Yeah, it's going to be just a cover. You're not extending beyond the side of the, what do you call it, the deck, nor are you encroaching further into the backyard, correct?
We are not going beyond the footprint of the deck. We just want to bring the columns to the edge of the deck so we can put the railing, the handrail there,
Okay.
make it safe.
Ms. Novak, do you have any questions?
I don't have any questions.
No questions.
All right. Mr. Dorr?
When we were out there on the scenes, I know you came and you pointed out where it is. This is gonna be integral in with the banister that goes all the way around, because there was a little bit of a drop off on that patio.
Yes, that's correct. So we have the
Built
existing.
into it?
Yeah, so I think there's a detail in the
Yeah,
construction
no, I
documents. You
just
just kind of
read it.
mount the handrail into the columns.
Okay. No further questions.
All right, Mr. Lapatos?
I have nothing, Mr. Chairman, thanks.
All right.
I'd
Anyone
like-
here for or against this application? Nope, okay.
Mr. Chairman, in light of that, I'd make a motion to approve Z25-7.
Okay, I have a motion by Ms.
I'll
Novak. Second by Mr. Dorr, Mr. DeChico.
Aye.
Mr. Lapatos?
Aye.
Chairman votes aye, carried 5-0. Good luck to you.
Great. Thank you, everybody. And thank you, Kathy, for helping me this whole process.
You're welcome, no problem.
Next application is 25-8. Sal Papage, is that it? Papage. I realize that.
You've
Je te
changed
dirai
since
français, du
Saturday.
monde est très difficile, monsieur. Yeah.
She has a desk in her office.
I was gonna say, you living here now?
Between, okay, let's get to business. Raise your right. Testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
You are.
Jonathan Belani with Annunziata Belani Design Consultants, located at 10 County Center Road, White Plains, New York.
Okay, now this is the premises located at 174 Elwood Avenue in Hawthorne, and on the tax map, it's 8912-17-1-58. And the application is for a proposed legalization of an existing one-story addition to an existing single-family dwelling on a legal substandard parcel, 5,000 square feet, in the R10 zone. Maximum lot coverage, 20% is required, existing is 23, going to 26.
Correct.
So actually, you're going about 2.5% more
Over
for what
existing.
you have now. Maximum lot coverage is 1,000 square feet, it's 1,175. You're proposing 1,300 square feet, so it's about 125 square feet. And the front yard setback, 30 feet is required, existing is 9.4, proposing 9.4, or a 20.6 foot variance.
Correct.
Okay.
Well, My client, Sal Papage, is located at 174 Elwood Avenue. I'm sure you guys have went to the site and saw that it's already there. So, in after the fact, I was called in to analyze the addition that was built, and because they were worried about a side yard setback, but in actuality, they're actually in compliance on the one side, but because he increased the nonconformity on the front, we're having to get that front yard setback, and the coverage calculation goes over. So we're here to rectify the situation and hopefully please the board. In my eyes, it's not an egregious addition to it. It's only about a total of, I think, 172 square feet on the addition. He's just bumping out a bathroom on the side of the house.
You said the front yards, I remember we were in the back and we saw that. I didn't check it from the front, so it actually runs parallel to the front face of the building?
Yeah, you continue the front face out, I believe, it should be on, I believe it's 7 feet, I'll show you. 7 foot 2 on the front of the house. You can see it's over right there. There was a bump out on that side of the house originally. He just extended it to the front.
Stupid question.
Yes.
You put up an addition with no permit.
This is why I'm standing here.
It's kind of an important question. I tell my
No,
kids all the
it's-
time,
no.
don't come to me asking for forgiveness.
No, and fortunately and unfortunately, I have one side of my business that is now taking care of legalizations. Of all these people who, I get called in after the fact. So that's what I'm trying to remedy. It's definitely a one-family residence. They intend to use it as part of their one-family residence on the first floor. They have an increasingly growing family, another baby. He has no powder room on the first floor and no laundry room. Wanted to put laundry room and bathroom on the first floor. Because their basement, I went into their basement, they have no usable space in the basement. Zero. So.
Well, I don't know. Ms. Novak, you have any questions?
Not at this time. It's a tough one. No permits. And I'm assuming, I can't assume that he knew, but I would expect a reasonable person to know before they bump out. And I like the reference of bump out, but it's a significant build out. There's not much shoulder length room between where we stood on the side of that and my left shoulder looking back out from the tree line.
Yeah, well, you have a brush of trees there, but in actuality, you have 11.2 feet, which you only need, I believe it's
10 feet.
So on that side of the house, as far as the adjacent neighbor, yeah, you required 10 on the one side, which you have 11.2, and they have an existing nonconformity on the other side is 9.8. So they're actually, as far as balancing the property in the middle, it's in the middle of the property. So it's not leaning one way or towards the other. It's just that, which all those houses on that street do not have a 30-foot setback. It's pretty continuous along that street where most of those houses on Elwood Avenue don't have a 30-foot setback. So he didn't increase it towards the street, he just extended it alongside the street. And I know his neighbor, there was don't believe there's any opposition to it. As far as his awareness, he's not from here, so I don't know what his awareness is. And I don't know how long they've been in the country, but I assume that wherever they were before, permits weren't.
Did he do the work himself?
I don't.
Yeah,
When I came in, I certified the work, I looked at it, I told him what to change, what not to change.
So it was actually done by a construction
Yeah,
company.
so I told him what he's gonna have to change, what he's gonna have to secure, and hardware and fastening, and I'm not structurally worried about it, as far as.
I'm worried the fact that
Liability.
we had a contractor put up an addition without a permit.
Mr. Chairman, it's still only 2
Yeah.
variances, correct?
So I just want to say for record, it's only 2 variances,
Yeah.
but the new program splits it by the percentage and square foot for the maximum lot
yeah.
coverage. But it's only 2 variances.
only 2
not
variances.
three.
Thank you.
So you know.
Just for the exercise, can you run through the argument for this addition in the hypothetical as if the addition, what it wasn't there and you were coming to us fresh as to why this should otherwise be granted if it wasn't?
Well, I've been doing this not only in this town, in Mount Pleasant, but in other municipalities. And there have been times where I've gone to houses and turned down, opportunities to legalize something because it's so egregious. And when I went into this house and went into their basement, measured everything, no usable basement, kid, he's an honest, he seems like an honest person, he has a child, I believe he's gonna have another child, and walked in, I know it was an honest attempt just to improve the house that it might have been his first house, or I'd have to find out what the circumstances are, so I have to try to figure out, but when I go to a job site, I make sure it's not an egregious ask, but also that it's safe, and stable, and so.
Would he have any other options if we wanted to put a bathroom, what other options would there have been if?
Not
Looking at a fresh shot.
Not with being in compliance, no, because any bump out would increase, he's already over on the coverage, so he increased it by 2.5%, right? And either way he went, left or right, front, left or right, he'd be asking for a variance.
Been feasible to go towards the back at all, or any better or worse, create different problems,
I mean, I'm sure he could have went out the back, but also he has this detached garage that's close to the house, so to infringe upon his yard. So
What about-
and plus the addition that was already there, allowed him to use that as a stable, foundation. He used part of it and used the new foundation part of it and used the old foundation as part of it.
What about conformity to the neighborhood if we were looking at this without the addition being there?
Well, like I stated earlier, all those houses are non-conforming. I would imagine if you went down the block and you did a survey of all the prices of the houses on Elwood Avenue, one or the other would need a variance. You can, go pick one, throw a ball at one.
That really might be your job, no? To come to us with a number of houses and number of feet that they're non-compliant. I mean, honestly, when my turn to address you was to come around, I was gonna ask you to develop the record a bit more and give us some, more than just a assertion that this variance, if it were to be granted, would be consistent with the neighboring homes. I appreciate the
I think if you-
assertion, but
Yeah,
I
if you drive down
actually
Elwood, it's
want-
kind of it's a safe assumption, but I could see you documented as fine, yeah.
Yeah.
No further questions.
Mr. Dorr?
I mean, based on the questions that we've had at this point, I mean, we're not looking at a lot of options I can see here of rectifying this like we did with the pergola in the previous.
Yeah.
I mean.
Which has been done, by the way. So follow
Good to
through.
hear.
I think to George's point, I'd like to see more information, not just hearsay driving down the street, on how does it change. I mean, I don't disagree with you. Driving down that road, I mean, it's a very highly traveled road. The fact that this was done without somebody saying something about it in the development stages when they're building without a permit in the window.
Yeah. No, I agree.
To that standpoint. So, I mean, the extreme option that I'm in my head is that it's got to be taken down, and I don't think that the owner wants that. So I think the more we have for the record, I mean, we don't have, I don't think, any other options. I mean, George, Nick has already asked if you can go back in the back of the house and slip it back there, and it doesn't sound like the person wants to close that price. I mean,
No, I
whether
understand.
he knew or not knew, I mean, that's not for us to tell, but, it's
Yeah.
not one of these things where, oops, now it's okay.
Yeah. No, I hear and as you look at the floor plan, the option is pretty limited because of he has a kitchen on one side. So he has a kitchen on one side and he has a dining room whose only access to the yard would be the other room. So if you put the powder room on that side, it would block the access to the back. But it's a reasonable ask to what extent, to document the other properties in the area, to show you the non-compliance of the.
Also, like the lack of the lack of other feasible alternatives, as we would on a standard application where they didn't build, because that's really the end of the day, the analysis that we have to undertake. As much as we might be upset that he built without permission, we're not going to deny somebody at least I wouldn't. I don't think the board would deny somebody a variance that they otherwise would have gotten solely because they built ahead of time. But we want to make sure the record is sufficiently established because we don't want to make this the precedent where people do this.
No, I'm totally in agreement. I can develop that for the next meeting. I can develop
I mean, just pursuant to the factors on the 267B to make sure that, again, the impact upon the neighborhood, consistency with the other homes in the community. I know you made the assertion But if we develop the record a bit more, it might
Yeah.
make other members of the board more comfortable,
Yeah.
as I know would make me more comfortable.
No, also, if somebody presents this, next time you can say why on Elwood Avenue non-compliance. No, the backup information is very reasonable to ask.
You can take an adjournment for that purpose,
That's
if you
fine,
like,
then
and
that's fine.
perhaps come back in no more than a month.
Yeah. Question is to what extent, meaning that, this can easily establish, are you guys okay with GIS mapping and measurements off of that? Because it's going to be very hard to document surveys off of every property unless you get surveys of.
If you take measurements and you go under oath,
Yeah,
and you assert what those measurements reveal, that is a sworn statement, that's evidence that,
and I would put
Would accept.
documentation together, it's just to what extent it's hard to ask a client to pay for surveys or look,
Yeah,
you know what I
yeah.
mean? So I want to just see what, reasonable research would be acceptable. We could discuss it too. I mean, I can talk to the building department and
Sure.
figure that out too.
sure.
All right, so you want to adjourn this,
Mr. Chairman, I move that we adjourn application Z-25-8 at this time to the May meeting.
all right, do we have a second?
I'll second.
Aye.
Second by Ms.
Aye.
Thank you.
All right, everybody says aye. That's it.
Sorry, there's a question, Mr. Chairman?
Wait,
Oh.
somebody have a question here? No.
Yeah, no,
Yeah.
coming up.
Sure.
You have to
Mr.
come in.
Chairman, reopen the public hearing on this matter before
Yes.
the adjourn date?
Yeah.
On consent, Mr. Chairman.
Raise your right hand. Testimony about to give is the truth, so help you God?
I do.
And your name?
My name is Vladimir Golden. I'm a next door neighbor, 176 Elwood, next door,
Which way?
north side. Next,
All right, that would be, that would be the left, right?
no, on the other side.
By the
yes.
driveway side.
By the driveway side, okay.
I've been living at my property for close to 40 years. I've had about 4 owners of adjacent property. This family is very maintains the property very well. They made many site improvements, and I don't have objections to the proposed changes. That's pretty much.
Okay. Thank you, Vladimir.
Thank you.
Thank you.
For saying
Thank you.
Okay, so this is going to be held over until the next meeting. Final application for tonight is 2514 New York City Department of Environmental Protection. Good evening. You're all set, huh?
I'm all set.
Testimony about to give is the truth, the whole truth, so help you God?
It is.
And you are?
I'm Kevin Ellenwood. I'm a deputy portfolio manager with the DEP. And this is her address, 0 Westlake Drive in Valhalla, or 20 Westlake Drive, works just as well.
Okay.
I have a-
So this is premises located at 0 Westlake Drive in Valhalla, designated on a tax map, Town of Mount Pleasant, 117.11-3-1. The application is for a proposed construction of a 10-foot-high wall for the relocation of Westlake Drive in support of the KEC project, whatever KEC means,
Eastview Connect.
with the construction of a new water conveyance tunnel between the KEC, again,
It's the Kensico Eastview connection.
that's what it's called,
Yes.
Kensico
Eastview.
Easement Connection. right?
Eastview. 'cause it's going
Eastview
from
connection.
Kensico to
That's where the
Eastview.
tunnel is
Okay,
connected.
thank you. Eastview site and the Kensico campus and supporting facilities at both locations. Legal parcel of 85 acres in an R40 zone. Maximum height for a wall fence is 6 feet, you want 10 foot, and you're asking for a 4-foot variance.
The board has to see it, so if you want to move to this side, you can.
Okay, so I have a brief presentation I'd like to go through if you'd allow. So thank you. I'm here to talk about the Kensico Eastview connection, which is essentially the construction of a new water tunnel from the Kensico Reservoir to our Cat-Del UV facility in Eastview. And tonight, I'm here to talk about a variance that we're applying for a wall height that we're constructing under the first contract, which is site preparation down the street at Kensico. And this is for a retaining wall along the new roadway that we're in the process of constructing. Okay, so what you see on the screen is the portion of the site that we're talking about tonight, and this is the final condition after we've completed all contracts, so 10 years in the future. I direct your attention to, it's called out as relocated Westlake Drive. That's this roadway here. Presently, Westlake Drive is a public roadway that goes through our property, bisects our site. So the idea is that we construct this new roadway on the northern edge of the site. North is to the left. And then that way we can separate public traffic from our operations. We can create a secured perimeter around the entire site, which is one of our most critical facilities in the entire water system. So previously we presented an application last August for 2 retaining walls. So there's the 2 Con Ed towers that I'll talk about. At that time, the board asked us to sharpen our pencils on a couple of points that we'll address tonight. And since that time, because of site conditions, we no longer need a variance for a retaining wall height for one of the 2 towers, and indeed it's possible we don't need a retaining wall at all. So tonight we're here to focus on the highlighted one there, right where my laser pointer is. Okay, so this roadway is constrained by a number of factors. There's some features of the town code that we need to comply with. There's the 2 Con Ed towers that have their own set of constraints. So for the town code, we're looking for the minimum roadway width of 30 feet. And then also we're looking to comply with the minimum K values. So that's essentially the vertical curves. So making sure that the curves, the steepness in that area is safe for passage for a roadway of that type and that speed limit, which I believe is 30 miles an hour. So those 2 Con Ed towers here and here constrain our path through the site. So our horizontal alignment, our path there is set. And then in order to maintain the maximum steepness, or not, avoid making it too steep, that dictates how much we have to cut into the hillside. And then also, as we'll talk about, we need to offset from the towers a certain distance in order to not undermine their foundations. So all of that combined means that in the area of the westerly of the 2 Con Ed towers, we require a retaining wall that exceeds the town allowable 6 feet. Okay, so this is a plan view of what we just looked at. Now north is up, to be nice and confusing. Here's Columbus. We're up here tonight. Here's the new roadway that you can see we're constructing now. This is where we have the road closed, and we're actually paving it today. Here's the Con Ed tower that we're talking about, and then the retaining wall around it. So we've applied for a retaining wall total length about 250 feet. We're looking to reduce that. We think that the wing walls, so the 2 edges, we can reduce it. It'll end up being more like 200 feet in total, we hope. The retaining wall tapers on the edges, so it ranges in height from 2 to 10 feet. Again, we want to make sure that we are conservative, so I'm hoping the peak height will be a smidge over 9 feet, 9 feet 2 inches, something like that. 29 feet from center line, and one of the points you asked us to take a look at is just the aesthetics of the face in general. So we've looked at that. It'll still be poured in place concrete retaining wall, but we'll face it with a stone veneer. And I have a rendering on that we'll look at the end of the presentation. Okay, so this zooms in a little bit closer. We talked about this a little bit on Saturday, and I kind of pantomimed the high points, but this just kind of gets into the numbers. So you can see the colored area, that's the entire retaining wall. And then on the edges, the orangish color, that's within variance. So that's 2 to 6 or 0 to 6 feet. The green area is about 15 feet. That's 15 feet total on either side. That's 6 to 8, so a little bit out of variance. And then, the greatest magnitude, 8 to 10 or 8 to 9 at a bit, that's that blue area where it's, right dead center of the retaining wall. And that's about 100 feet. So certainly not the existing conditions today, but this had been the existing conditions less than a year ago. So the picture on the left is top of the hill. The high school is to the left. The reservoir would be in the background. So this is top of the hill looking at the Con Ed Tower. The picture on the right, that is on Columbus Avenue. The reservoir would be to the left, our upper effluent chamber, that building that's kind of in the water. It would be just off frame. And that's a picture looking southwesterly at the tower in question. And right where I have the pointer, that's about where the new road is cutting in. So you can't appreciate it from the photo on the left, the steepness of it. You could see it a bit more on the right. So this is the current conditions as of this morning. It's actually already totally different, but this is the paving operation. So generally the same two photos. The image on the left, that's looking up towards the tower. You can see the gravel Con Ed entrance ramp, or I guess that's an exit ramp for them. And then you could see a drainage swale there. What I want you to take note of is you can see from the top of elevation to the road just how much we had to cut out of that hillside in order to keep the grades manageable. Image on the right, we're in the midst of paving. The interconnection between the new road and the existing road, that section it was completed today. We still have some more work to do, but we should be finishing up with that very soon. Okay, so this was the other point that the board asked us to look at in August, and then most recently with this application. So the question is, there's a lot going on here, so I want to take some time going through this. The question is, instead of a 9 to 10 foot retaining wall, can we stagger it with 5 to 6 foot walls that are within town variance? So this demonstrates what that would look like if we did do 2 retaining walls that were within variance. So just to orient everyone, we've got the roadway here. We've got the roadway here, drainage swale, a lower retaining wall, and then a second upper retaining wall within variance, guide rail for fall protection, and then here is the Con Ed Tower, and this is the foundation. It's an augured pile. So this horizontal distance is dictated by the height of these walls and the influence that one has on the other, right? So we have a certain offset between the two, 16 feet in this case, approximately, such that the upper retaining wall is not influencing the lower retaining wall, and then likewise another roughly 16 feet for that second. So here we're dealing with two sets of criteria, two requirements from Con Edison. The first one is a 40-foot buffer around their towers, all around their towers, and that's for maintenance, so they can bring in their trucks, their cranes. That's what they require. So if we take into account, the structural requirements of these retaining walls and this guide rail here, there's 25 feet of clearance in between the guide rail and the tower, so clearly not meeting the 40-foot. This is something that we've discussed with them, how flexible it is. This is admittedly the softer of the two requirements. They can negotiate on a few. There's elsewhere with our design, we have 37.5 feet of clearance, and they will live with that. But this is a great departure from their needs there. So that's one issue. The second, the more important of the two, is the foundation of the tower itself, and they require a 25-foot buffer from their foundation, so that pile, and our loading. So here, again, it's the same requirements for the retaining wall, and here we have 21 feet of clearance, so we're not meeting the minimum. But something to note beyond that, the reason we're not doing anything with the other tower is because it's shallow bedrock, and that works to our advantage because it acts as its own retaining wall, but then also that tower, the augured piles are embedded in the bedrock. Here we don't have the bedrock, so those piles are floating. They're also raking piles, which means that they're not vertical, they're inclined. So in addition to not meeting 21 feet from the top, they're also inclined, so they are actually coming closer to our retaining walls. And we don't know exactly how close they are, so there's a great risk in undermining that. So, because of that, because it's critical infrastructure for the region, and it's a safety concern, we feel that, the single retaining wall with a variance request is the only way to go. Questions?
You said they need 40 feet, correct?
40 feet for maintenance on the top, yeah.
You got 4 sides to a tower.
Yeah.
3 sides are 40 feet. Each one has about 40 feet, except for the front facing the two-step. Am I correct?
Yes.
Okay.
Yeah.
All right,
So we could, I don't have those dimensions here.
Roughly, it's 40 feet. You have at least 40 feet to the left, the right, and the rear, but not
Right.
in the front.
Right. But, yes, sorry, go ahead.
Okay. The other thing is, you're showing 21 feet. The support anchor, we'll call it that, that goes down probably about 20, 25 feet?
Something like that.
Okay.
We don't, I don't personally know.
No, I know, just ballpark. Now, that's low, the upper wall, let's call it the upper wall, is actually more than 25 feet from the foundation. It's actually more like maybe 35 feet. Because you have an incline of about 15 degrees, 20 degrees from the wall up.
Well, that's, so it's the influence of that we can't have within 25 feet of the pile.
No, you know what I'm saying? You
I
got
do know what you're
25
saying.
feet,
I do know what you're
and then
saying.
you got additional footage before you come to the retaining wall.
Right, but you can't, it's this here that's the issue, right? We don't measure from here, sorry, I'm having trouble. We don't measure from here, you know, we measure from the influence of this, which is in the 21 feet. And that's from the top, right? Not the bottom, and the bottom is actually coming closer, and we don't know, you know, we don't have as-built, and there could be, you know, it doesn't necessarily go, when they auger the pile, it doesn't necessarily go straight in, so it could drift. So we just don't know, it's too big of a risk.
Right, but when we were out there on Saturday,
Yep.
we were talking about a graduated wall, single wall, graduated, going from about 2 feet up to 10 feet, maybe less, and then coming back down again, correct?
Correct.
Okay. Are there going to be some vegetation in front of that wall?
Yes, yeah, would you like me to show you that?
The reason I
Rendering
say,
as well, you said stone face, the rendering.
yeah, the reason I say that, when we had the, excuse my vulgarity, when we had the tornado come through town, and it went through Nanahagan Road, through the reservoir, that section over there is like a weed farm. It lost all of the trees and everything, and nobody ever did anything about it. And that section of road from the traffic light up past your water pump station, whatever that is, and you come up the hill, you know, it was pretty bad. So now this is in a public area. People come by all the time, because I've lived here many years. And I remember the aerators were here. People would come up, go to the beer garden at the end of the Kensico Dam. We don't have that anymore. Ever since 9/11 and everything else, things changed.
Right.
But if someone's driving, like I would be driving down the new Westlake Drive to go home, let's say, I want it to look nice.
Agreed.
Yeah, well, right now we got, I know there's construction, so, and you mentioned that there will be some distribution of soil to sort of remove some of the impact that what we have now.
Yes.
Correct?
Yes.
All right. I'm just want to be certain that when everything is all said and done, that we have a nice looking area, because we all live here.
Sure. Yeah, so I can show you part of it. It's not going to get to all of that. I can speak to your concerns there, but that, I don't have that for the retaining wall right
Just
now.
what pertains to this now,
Okay.
the pictures you have.
A few questions, Mr. Chairman.
Okay, so this isn't what you're looking for, but we are doing that, right? So this is facing the reservoir. You have the Con Ed Tower on the left, and then that's basically what the stone veneer face would look like. And then on the right, the final contract, 10 years from now, that's where we would install the permanent perimeter fencing. It would look something like that. I don't think it would look staggered like that. I think that's just the way the model renders it. But just briefly to your point, in this first contract, we are planting grasses and a meadow mix and wildflowers and things like that, and that's it, because the contract is not long enough to meet our own requirements for invasives control and establishing plants and trees and all that. However, we recognize the importance of that. So in the next contract, we're pushing the contractor to do that work now. So this contractor is working on this road, and we're going to have the second contractor, the tunnel and shafts contractor, put in those bushes and plants and trees and shrubs and all of that in this area before we convey it to the town. So, we're not constructing on a public roadway.
All right, fine. Any questions from the members of the board? Ms. Novak?
The secondary fence, it's the point of day where my eyes are not working excellent.
Yep.
But that secondary row, that is the second fence in your other rendering, which was more stick-built.
I'm sorry.
The
So-
fence near the.
Yeah,
tower.
the secondary fence, the higher
here?
fence. So
Yeah.
that in your other rendering is the second.
So this is the retaining wall here, and this fence here, that's really like a fall protection. I think we have it as a 4-foot fence.
Okay.
It's really just at the top there, and it's really just for fall protection for Con Edison workers if they're up there.
Okay.
Or, if we've got kids trespassing, they don't actually accidentally, walk off the side.
Mrs. DeChico, any questions?
A few questions. It's fair to say that the site has been operating in its current format with the Westlake Drive bifurcating it for the several decades, correct?
Yes.
And it would also be fair to say that if there was some reason, engineering-wise or other, that you weren't allowed to build the road as you're planning, that if the road had to stay where it was, the site could still operate in a sufficient fashion, even with the planned new buildings, correct?
I would disagree with the word sufficient, but yes, it could operate.
It could operate. So this new road is not essential. It is something that is, it is a luxury for you guys to bifurcate the site, to have a site that is no longer bifurcated.
I disagree with that.
Disagree with that. But the site would still pump water to Eastview even if the road stayed where it was?
Correct.
Okay. So one of the things we spoke about last time was the disruption to the community by taking away all of the parking on Westlake Drive
Yes.
and the overflow parking. Remember this, right, sir? We did
Yes,
speak
you'd have
about
to
this.
clarify what the overflow parking is, but yes, I do remember this
Well,
discussion.
there's parking on Westlake Drive, which is used by the students
Correct.
and staff and people for events and overflow every day. And that is no longer going to be available because there's no more street parking on the proposed Westlake Drive, correct? On the new Westlake Drive, there's no street parking. There's no street parking,
Correct.
correct? And you are building a new parking lot of a certain size to add some additional capacity to make up for the...
30
for 30
spaces.
spots.
Correct.
But that is a locked-in lot with no ability for overflow. It's really locked in for 30 with no expansion plans or anything like that.
So we are providing 30 spots. It
Right.
becomes the, not the property, but the school operates and maintains it.
And we spoke about previously that there was an opportunity here not only to provide just a very small number of 30 spots, but perhaps more to allow for sufficient overflow parking and also to allow better access to the fields. Do you recall speaking about this, sir?
I recall you asking.
Right.
You'd have to define what you mean by providing access to the fields, though.
Providing more parking to account for events and use, and providing better access to the fields just behind the building, which this road goes right by. We spoke about that, and I asked you if you would try and look into being more accommodating to that, noting the once-in-a-generation opportunity we have. And I believe you said you would, and I don't see any change to that here. And I'll read to you, and please let me know if I'm missing something, but the plan is still only for that very small, tiny parking lot up front, correct?
We are installing a parking lot that will accommodate 30 spots.
Right.
Mr. DeChico, I think that was already planned by the town board and the
How-
planning board and out of our jurisdiction.
I don't
that
think
we're
it
here
is,
tonight.
Mr. Dorr, because I'll read to you.
It's already been approved, to my knowledge.
Well, we have an opportunity here, as per the zoning code, 267B sub 4, to impose conditions. And I'll read to you exactly what the law states. Again, for the board, because we seem to have an issue with conditions on this particular property. The Board of Appeals, in imposing conditions, shall, in granting of both use variances and area variances, have the authority to impose such reasonable conditions and restrictions as are directly related to and incidental to the proposed use of the property. Such conditions shall be consistent with the spirit and intent of the zoning ordinance or local law, and shall be imposed for the purpose of minimizing any adverse impact such variance may have on the neighborhood or community. They are taking away numerous spots. They're doing the absolute bare minimum to try and account for that, and I don't believe they are sufficiently accounting for these spots that they are taking away. Nor are they accounting for the ability to use overflow parking, nor are they accounting for the ability to do anything other than the absolute bare minimum. The disruption to the community is not being accounted for by what they're looking to do. They don't need this road. This road does not have any effect on the operation of this facility as it operates now, or as proposed to operate. It is a luxury. I understand it's reasonable for them to say we want a site that is not bifurcated by Westlake Drive. That makes sense. But if they're going to do something that's a nice to have, not a need to have, then they should properly account for the adverse impact on the community. And we have an ability to impose proper conditions that are directly related to and or incidental to the request. And I believe strongly that imposing a condition that they provide more parking for the high school to account for the spots that they're taking away from is more than reasonable. You may not agree, and the board may not agree, and that's perfectly fine. But my position is what it is.
Okay.
I have a few more questions.
Okay.
Can you explain to us, and for my own edification, the timeline of events here since you were last here in August? Because you were on the agenda, and then you were off the agenda, and then you were back on the agenda. So
Sure.
did you pull the application, or did something else happen?
Yes, so I went over that very briefly.
Okay.
I can go into it in more detail. I don't know if I have a slide on that, so just bear with me, please. Not really. Okay, so when we presented to you in August, we were working in this area. As I mentioned, we were applying for a variance for both retaining walls. Here's one. When we began excavating in this area, we encountered rock much shallower than we anticipated, and then we actually have a change order to the contractor to deal with it. That allowed us to reevaluate the design of that retaining wall, and we spent a long time looking to reduce the height of it. We were working with the town engineer and the town building inspector on options that could work for us. So at that time, we adjourned the application. Since that time, we fully excavated and paved, not completely paved, but started to pave in that area, and we determined that we do not need a retaining wall for that Con Ed tower that exceeds 6 feet. Indeed, we may not need one at all. So we need to finish the excavation there and have the town engineer come out and confirm that that rock face is competent rock, and then we have no need for a retaining wall in that area. We are hoping for something similar, and we're working with both the town building inspector and the town engineer on coming up with designs that would result in a retaining wall that's within variance.
So the application was never pulled.
Well, you can correct me on the technical details,
It was
but yes,
modified.
I believe, I don't know the right terminology, but
Okay.
it was essentially canceled, and this is a new application.
This was a brand new.
Yes.
Okay.
Yeah.
I have a question. How many cars park on Westlake Drive now?
Well, there are no student parking on
There used to
Westlake
be.
Drive. It was, I mean, anecdotally, in my observation, it was about 30
How
or
many?
less.
How many cars you think used to park on Westlake Drive between Columbus Avenue and up to, I guess that's where you used to get the old fishing permits, that building over there?
Yes, so as I said, just my observations, because I was concerned about this after we spoke, it was about 30.
And you're proposing 32 lots, 32
30.
spots?
Yeah.
And
Now,
you know-
since that time, pardon me, the town building inspector got in communication with one of the owners of the restaurant across the street, and it was a great opportunity that owner allowed the students to park in that lot there, so they're closer to the school. They're no longer driving, through our construction area, and they no longer have to walk past our construction area. They're just going right across the street. So I can't take credit for it. That was 100% the town building inspector who did that. So currently, with the active construction we have going on that public roadway, there are not any students parking in that area because they don't need to.
When the construction ends, there's going to be a closed-in 30-person lot, but on a night that there's a school play or a game, there's no ability to expand. It's locked in because people cannot park on the street now, cannot park on the new road as they could park on the street in the old road. Is that fair?
All I can say is, we were building this lot for 30 spots. It's not my firsthand knowledge, but it's my understanding that the town attorney made an interpretation about this and, disagrees with your position.
And in what sense? I haven't seen an interpretation from the town attorney.
To enforce greater than, a change to the parking lot.
Well, that hasn't been shared with this board.
Okay.
The conditions, the statute for the conditions are there. Reasonable people could disagree whether or not this is directly related or incidental to the use. I understand that. However, the idea is that when you have all this equipment there, you had every opportunity to build a bigger parking lot that would accommodate not only the bare minimum average needs, which doesn't mean the everyday needs, but the bare minimum average needs, as you've told us anecdotally, but also account for needs going forward. And you haven't done that.
So we have been working with the town for a number of years, working through the planning process and working with the town on the design of this project, which includes conversations about the parking lot. And we prepared an application, which we presented to the planning board, and that was approved. And then we presented to the town board for a special use permit, also for the same construction, and that was also approved. So we did go through a process of communication with the town to settle on the contract that we're currently constructing.
And during the process, if you had somebody that said, hey, we think 50 spots might be good, that could have been done relatively easily to build another 20 spots, say, during the time. But now to go back later, it's going to be quite a chore to build any additional capacity for
parking lot is constructed and paved.
Right.
All right, Mr. Dorr?
No further questions at this time.
Mr. Lapatos?
I have nothing, Mr. Chairman, thank you.
Before I ask questions of the people, if I recall at the high school,
Yep.
there's a lot facing the high school, there's a lot to the left. Is that correct, Mr. Briganti? In front of the high school, by the parking lot, you have your parking lot in the front. There's a section of land to the left of that,
By the tennis courts, yes, there's the lot, firehouse.
before the firehouse. Before the firehouse.
It's the senior lot right now.
Senior lot, yeah.
Because my daughter parks there.
Right,
Right now,
that's
she's
a-
currently in Sergio's.
All right, that's a senior lot?
It's a senior lot.
I don't park there, I just go through it, pass it, I'm closing. How many cars go in there? I mean, we got two constraints here. I know where Mr. Chico's coming from. And, sports is very big, football, so on, baseball, and you get big crowds. And the ability to satisfy the requirements of those crowds is demanding. And first of all, I don't think we have the room to support very large crowds on the high school property.
Mr. Chairman, that's...
Right. I pass there, even when they have plays. Parking lots, you can't find any spot. Okay? So that locks that in. And then now we know that there were originally 30 cars that used to park on Westlake Drive. And now we got 32 cars with the new addition. And also the fact that Sergio's is allowing their students to park in the back where the house is and everything in that area. Do we have anything in formal writing on that? Or is it just word of mouth?
I don't personally know the answer to that.
Mr. Chairman, I believe we informed anecdotally that the average number of cars is
Yeah,
30,
and-
which means sometimes
say
it's
up to
more
30.
and sometimes it's less.
Yeah, but there is enough relative parking on the existing Westlake Drive, the old, let's call it the old Westlake Drive. This is the new Westlake Drive. I think at this point, is there anyone here who has any questions? Gentlemen, could you please come forward? One at a time.
One at a time.
Raise your right hand. Testimony about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
And you are?
My name is Nicholas Saldi. I live at 2 Fountain Drive, Valhalla, New York. This is my neighbor Dino. He lives across the street at 1 Fountain Drive, Valhalla, New York. My dad, I've been here my whole life, 68 years. My dad did that subdivision, Fountain Drive, Ann Place, Allen Place. There's no drainage. It's 1907. There's no drainage in that place. It was built in 1956, okay? Now, he also did Ann Place. It was a beautiful view we had. Growing up, it was aerators, it was gorgeous. Okay, times change, aerators fill in. And like Nick said here, he's 100% right, because I went to Valhalla High School. He's 100% right. The way that parking is, it's horrendous. They did a parking lot for the construction workers. I was in the business. I spent 1907, my grandfather started. My father took over, then my brother and myself took over. We know, okay? Now, what they did, across the street from my house and Dino's house, they built a stockpile mountain, okay? Oh, wow. You know, they're gonna stockpile until they finish the building? I don't think so. They put landscaper fabric over it and eroded. Put the landscaper fabric back. Go higher and higher. I know, being in the business, when we do an addition on a house, engineers design Coltex, they design, you know, you make a driveway bigger, oh, you gotta control your water. Well, how were they controlling that water? They built a mountain. They have, don't get me wrong, they have retention basins on the high end of Westlake Drive, and on the low end of Westlake Drive, it's a tiny retention basin. Up by Valhalla High School, where the old aerators were, they did a beautiful retention basin, nice and deep. My side, and Dino also got flooded. In the flood, you diverting the water to come down Columbus Avenue. What? And they're making a, you know, hopefully I asked some guys on the building department, the head of the building department, I said, what are you gonna do? I don't wanna mention no names, Sal. He goes, oh, that pile's gonna get cut down. I says, oh, really? They're gonna get cut down? You mean, the original plan that they had, the landscaping plan didn't have no elevations on it, and it looked pretty much level. Now, they built up 75 to 100 feet over Westlake Drive. Forget about over Columbus Avenue, you got a Taj Mahal mountain there. It's huge. And they put my house and his house in a hole. Well, is that gonna stay there? Are they gonna move all that dirt again and cost double the money to move it out? Of course, all the neighbors are concerned, and they asked me to come and talk, because I've been in the business. Again, 7 o'clock in the morning, I hear the hammers running. I worked at Harrison, Rye, White Plains. We have laws that you can't start hammering until 9 to 3, and that time limit. I hear 7 o'clock in the morning, I just retired. I feel like I'm back at work, 7 o'clock in the morning. But we had respect for the neighbors. that will not start hammering, and there was laws in Bry, Harrison, Greenwich, forget about it. You couldn't start a hammer until 9:02, and I had to shut the hammer off 2:58. Stop hammering, no hammering. I hear my friends up on Fox Hill, they hear, what is that, a pile driver? They don't know. I said, no, they're hammering rock. And what he said, that building that parking lot, they had a 12,000 foot-pound hammer up there. They could have hammered that parking lot out in a half a day. Come on, who are you kidding? Make it bigger. I'm from Valhalla, I lived there all my life. I went to Valhalla High School, and you hit the nail on the head, Nick, what you said about parking. It's a joke. They did the parking lot for the construction workers to park their cars. I mean, it's not for the town.
I got a question for the building inspector. I was under my understanding that the construction's supposed to start after 8 o'clock in the morning.
8 to 5.
8 to 5.
8 to 5.
And why would-
8 to 6 during the week, 8 to 5 on Saturday.
No, but the hammering of rock, we were zoned. Oh, we could start, we're not, White Plains, Harrison.
I don't know, I'm concerned about here.
This town here.
I understand that.
Do you have?
Wait,
Let him finish, please.
I'm right, I'm concerned about here. It's supposed to start at 8 o'clock. So if they're starting before 8 o'clock,
I think he got permission.
they got permission? Who gave them permission?
But they got permission, I don't know if it was part of the planning board or...
And sir, I'm sensitive to that fact. I live on the other side of Mount Pleasant, but close enough to when the sawmill was being raised.
Yes.
And they were doing pile driving to the same extent as jackhammering rock. Same thing. People complained, just like you're voicing your opinion, and the town and the village of Pleasantville gave them permission to expand those hours to get the job done sooner. Because this is a temporary situation. As you know, as you're building any construction project, that jackhammering is not going to be going on the whole time.
Right.
A lot of this work, once this prep work up on the front is done, it's all going to be underground. And to my education and knowledge that I'm aware of with this project, the project is actually coming from that side.
Right, they're working
And
up.
most of the dirt that is, and most of the material is being put on that side. Will there be a mountain, whatever name you want to call it, right there in Valhalla? Because I understand what you're saying.
It's an eyesore.
I came up to this area with the aerators, technology changed. Is it an eyesore for all of us for a while? Absolutely. But to our education and knowledge to the project that's being done, that is also going to be lowered down. There was a mound over by the medical center from the initial, when they did the plant that's underground for our water, that the benefit of us.
Ultraviolet.
There was a mound there for a while too. But we're talking about a very large battleship, being the New York City DEP, and it took them a while. That mound is now gone. All right? I don't know exactly how long it took, but it went away. A lot of people didn't complain about it because it wasn't in a full residential like what we're all experiencing. All right? So your points are all valid, but most of your points need to be directed to the planning board and the town of Mount Pleasant, not to the zoning board. I mean, the parking and those issues that were brought up, that's also, that's a little bit different, but a lot of these concerns about what's going on that project site is not us. Tonight in front of us, they're asking us permission to put a safety wall, because ultimately this road that's going through there is gonna be a public road that everybody's gonna have to travel and use. The other one's going away, I understand it, because the gentleman also mentioned, it's one of their most high-security areas, so whether we're talking about parking spaces for kids or not, it's not becoming a prison. A road is...
We can have an exchange, we can have an exchange off the record.
I'm addressing here, I'm not defending anything, but what I'm saying is, that's all being worked out and permission was given. I mean, there's nothing that we can do here. I don't want you to waste your time and your concerns, because I value them very much.
Right, is there plans to move that mountain? Or, you know?
To my knowledge is that stuff gets taken away. Some of that retention and all that is temporary. I mean, I don't have those plans in front of me because we're not the
Yeah,
planning
but
board.
with the plans I saw.
But I go into the building and then I ask and I look at plans over the days because you see these big projects. I mean, I don't want to be here all night and everybody, you know, voicing, because we'll be here forever complaining about things that we want to get nice. And that,
Well, my
it's not
house
we don't have those informations to give you a good solid answer other than going to the town board or the building department and questioning exactly what you're asking. I don't have those points in front of me. I'm not privy to all those type things. I mean, we are educated. The planning board might have a little bit more, you know, from that standpoint. So I totally value, and I see what you're saying from a construction standpoint and building. But this is a project that digging underground is not easy. You know, if you want more experience on a similar situation, I ask you to travel up to Dutchess County in Roundabout. They just completed a tunnel that came through, that went under the Hudson.
Right.
So if you're talking about an amount of dirt, I mean, this is not a little project of building a
Oh,
house
no,
or a
I know.
parkway.
We did massive
So it's
tunnel.
above the scope of most contractors, you know, from that standpoint, so.
I was just concerned about his house, he got flooded.
And that's valid, I feel for you. I mean,
And there is no,
Wait. Mr. Dino, you're gonna have an opportunity to speak, and then you could have the full exchange. It's just, everybody has to
I'm
be
trying
sworn
to-
in.
Yes.
You haven't been sworn in yet, and no way am I trying to prevent you from speaking. It just, everything has to be done in a certain order, and believe me, you're gonna have your opportunity, just like this gentleman. Just be patient a bit. That's all.
I'm just trying to put some parameters on it. I
A
mean, I
question.
can see you're frustrating and where to go.
a question now. I know construction goes from 8 to 4:30, right? 8-hour day, a normal day. But the hammering of the rock,
I hear you.
does the town
You have to go to the building department or the town board.
Time limits when you start hammering rock?
I don't know about hammering, but work hours are 8 to 6, as I mentioned, but that's when they got permission to start.
Sir, that question is more appropriate. You could, any day, you could address the building department with those questions. It's not,
Mr. Pinelli might be able to
not
help you out
really-
on that.
unfortunately, it's just not something that
Okay.
this board is really.
I just wanted to get, you had the DEP here, 'cause I wanted to ask him about that, you know, what's gonna happen. If it gets taken down another phase of the job, the way the money is done, I totally understand. You know, if it's gonna get another phase, another section, I totally understand. I was just concerned, you know, I saw that it was eroding, and they went up there the next 2 days, they put the fill back, and they put the mats back on it, you know, and the water, there is no swale, or there is no retention basin on this side. It's a small one, and the water is like, I'm right at 2 Fountain Drive, and the water, the land is higher, you know, where behind the aerators than the road. So the flow doesn't change. What's that?
Sir, we can't
with
have
him.
this back and
This has
forth.
to stop.
Sir, if you have questions, you're gonna have to take these questions either to the building department or maybe even after the meeting if people grant you the courtesy of answering you a few questions afterwards.
Thank you very much. Thank you.
Okay.
Thank you.
Let the next gentleman speak.
Anyone else wish to speak, other than, you know,
Of course.
yeah. Raise your right hand. Testimony about to give is the truth, so help you God? You are?
I'm Dino Mondelli. I live at 1 Fountain Drive. So when my house gets flooded, so do we do what everybody did, Sandy in Long Island, build it on stilts? Do I gotta continue to lose my house? I paid with my own money. I understand they're building the project. I also gotta raise a family in this neighborhood. So what do?
I would suggest...
Allow them to do what they're...
No, I suggest that you speak either to the town engineer or speak to the building inspector. Those two people would have a better understanding of what your dilemma is. All right?
And like Nick said, we lost our view. I don't see trees, I don't see water no more, nothing.
I agree. I agree
So
with you.
now the value of my house goes down. What am I looking at, prison walls that they're building?
No, it's not true. The fact of the matter is, it's a temporary thing. We're gonna put all this dirt. Can't put it in the reservoir.
Okay.
We can't
Even the
move...
foundation walls that he's building.
No, the idea here before us is a retaining wall to make sure that a electrical tower is grounded safely to the land. That's basically what it is. So we don't have a problem in the future with erosion or anything else that it's going to fall over. The questions that you're presenting to the board are building department questions, town engineer questions. They're right across the hall from each other. and it would pay for you to come in and talk to them. Really.
Chairman, a lot of it also should be suggested to the planning board and recommend you go to the planning board meetings and bring up questions to them.
If it's on the agenda, yeah.
Still's on the agenda there.
Is it still on the agenda with the planning board?
Not this contract, but multiple contract, multiple opportunities to get public feedback.
Yeah.
I think that's where all of this dialogue has to go.
So, for the
It's
next
not our
9 years,
jurisdiction.
this project's being built, I could lose my home.
Sorry, but the question for tonight is
Okay.
the retaining wall that's
Okay, I'm sorry.
proposed, and how does the retaining wall affect you or the community? I understand the issues with how it looks now, but the amount of dirt is not necessarily an issue for the retaining wall that's being requested. I understand your concerns.
I'm sorry.
Sorry.
Nothing
I have-
to be sorry
Yeah,
about.
you
it.
don't.
Not sorry, sorry.
It's an
I have
education
just
process.
one question for the gentleman from the DEP. Is there a schedule? I don't know how long this tunnel is going to take to be built, but in the final sections of this, what is the general plan for the distribution of the excess dirt? Where is it going to go?
Right, so this first contract, what we're trying to do is create a balanced site. So that means any of the soil that we excavated for the road and the other things that we have to do, the construction of the screen chamber, we place it on site. So while it's true to say that our intent is to lower that elevation, we're not going to remove it, and that is for two significant reasons. One is we're trying to reuse soil on site and not divert it to landfills. And the other is to reduce the impacts to the town by having to truck out all that material. So that's why we're placing it on site. Yes, you're correct. We intend to bring some of that soil from where it is now, the larger of the two mounds, north on the site towards the end of the contract when we're demobilizing. But we heard from the building inspector the concerns about the aesthetics of the mound as is, and I recognize we're building to the elevations that we submitted in the plans, but I recognize that there's a difference between seeing it on a piece of paper and seeing it coming down Lakeview Avenue. So rather than wait until that later phase, we're working with the building inspector and the town engineer on changing the phasing, and we just submitted a plan to them this morning to reduce the elevation under this contract, and we are going to issue a change order to the current contract to do that. I hope it's not a lot of money, but we are sympathetic to that, and we're working on it, and we have other plans in process with the planning board, and we're modifying those a bit as well to improve the situation in that specific area.
All right. I have no further questions.
There might be some more people in the community,
Okay.
Mr. Chairman.
Ma'am?
You have to-
Hello? Raise your right hand, please. Right hand, thank you. Testimony you're about to give is the truth, so help you God.
So help me God.
You are,
Patricia Walker.
and you live where?
I own a house on 33 Highclere. And my question is a couple. One, the vagueness of what it actually is going to look like as far as the decorative stonework. And also, I don't hear anything about, like, there's a big water problem. You got a 10-foot wall. Is there going to be some kind of system to take all that water coming down the hill away? It seems very vague. It's just a retaining wall, but there goes a lot behind a retaining wall. There's going to be water pouring down it too. So I would imagine there would be a water problem on that roadway. Am I correct?
So if you could just,
But we do what we do.
ma'am,
Ma'am, if you could direct your questions this way, thank you.
I'm sorry. Okay, so that was one. And the other was the picture of what it's supposed to look like. That to me was like really pathetic.
It's a lot nicer than the first one.
Oh, really?
I agree with
Well,
that.
anyway, it seems to me that you could have put a little bit more effort into actually showing us and what this stone wall is gonna be, and then the iron gates across it is getting pretty scary looking. It is kind of a nasty drive now instead of a beautiful one, if you're gonna be putting gates and walls everywhere and no vegetation but some flowers. Anyway, that's my complaint. Sorry,
Thank
that's
you.
it.
No reason to be sorry, as many members have said.
Wait, just one thing, and I'll ask you who I should talk to. So trying to get in and out of Highclere is almost impossible in the morning when the schools and the workers and everybody is coming in and out 2 times, and again late in the afternoon. You can be there for 15 minutes trying to get out. So at one point I had asked about getting a light put there, and I was told by the board that someone would supervise the traffic and determine whether that would ever happen. And I don't see any lights. It looks like...
Ma'am, I'm sorry to interrupt you. That's not an issue before this board. We are here solely
Okay,
today
so
to
who
hear
would I
about the
speak to?
retaining wall.
Traffic and
County road.
safety,
Well, no,
traffic
that's
and
county
safety.
road
So
anyway.
it's
County road.
Talk
Yeah.
to traffic and safety and coordinate that with the
Mhm.
county and police.
So we have to...
County road.
Okay, well, I was told that they
Yeah.
were gonna
Well,
do
you
all
can
that.
speak to traffic and safety also.
Okay.
Okay. Anyone else? Okay.
Mr., do we want to give the applicant any chance to make any final comments?
I'm at a loss for words. I mean, we have a wall. It's going to be a variable height wall. And we're talking conversations about aesthetics of what the wall's going to look like. Fine. If they're going to build the wall, it should be like if you lived there, you know. You don't need mafia block, you don't want a mafia block wall holding back things. It should be something nice.
Yes,
And
it's
the
not-
proper vegetation. Like I said, if you go on Nanahagan Road from 22 all the way up, it's a weed farm. And this is a major area of our town. And I've given up a lot. I've given up the aerators, I've given up the beer hall at the end of the Kensico. I even gave up the Kensico Dam because I can't use it. You gotta go down into the village and you're there waiting for the traffic light to change with about 500 of your closest friends in their cars. I don't know when that's gonna open up the top of the dam. It would be lovely just for passenger cars. And everybody knows, even if you put a bomb in a truck, it's gonna go up. Bombs don't go down, they go up and sideways in their explosions. So my main concern right now is, since we live here, we have to do certain accommodations because of the construction work that has to be done. And I'd say let's get the wall squared away in an expeditious manner. Let's get the dirt. You got 88 acres. I did an addition on my home. I put a 600 square foot addition on my home. Not a drop of dirt left the property. We just reallocated it.
Mr. Chairman, I was just more hoping to see if we could get any rebuttal comments by the applicant before we moved on to a business session or whatever we may do next.
I don't think he has any rebuttal comments.
If he does, that's okay. Usually we give the applicant a chance to comment again after the public has commented in case he had anything to say in response to what was said.
Right.
If you don't have to, but
I
just
am,
giving
I
you the
am
opportunity.
happy to speak all night and to address as many concerns as possible. But as you pointed out, what's of relevance tonight is the height of the wall and, you know, the aesthetics of it. I apologize, you know, the rendering software is what it is. It's called Stratford Cross. It's actually, I think, very nice looking, but that's my own opinion. It's not concrete relief. It is, you know, stonework veneer on it. And for what it's worth, it was presented to the Public Design Commission, and they've approved it for elsewhere on other phases of work.
Okay.
And, you know, for the height of the wall, we really get down to less about the access and maintenance and more just about the structural integrity of the
Right.
fence.
Now, that wall may not be 10 feet, it could be a little less,
I'm
roughly. I'm
not
just,
committing to, you know, we'd like to get, we're seeking
I
approval for 10
understand.
feet, but I'm going to try and keep it to 9 feet.
I've learned years ago, there's a big difference between theory and application.
Exactly.
Any more
So,
comments, sir?
Not for the record.
So,
Okay.
Mr. Chairman, since the applicant has no more comments in response, I move that we go to a business session on this so we can discuss a few issues before we, in all likelihood, take a vote on this matter.
Do I have a second on this, or?
I'm ready to go right to vote.
Oh, yeah, so am I.
So the
Mr.
board would
Bartos?
not like to make a record, it would just like to move to a vote. Well,
Yeah.
I'll make my comments when I vote, before I vote.
What we're basically voting on is the retaining wall.
I'll second Mr. Chico's application to go into business session.
All right. Ms. Novak?
Aye.
Aye, what? Aye, you want to go to?
I will go into business session.
You would
Aye
like?
for business session.
Okay. We'll have a business session now, and it'll be closed to public comment.
So, presume that and nobody else has anything to say, hold on. Thank you for moving into business session to the members of the board. Just like to point out again that the 267B statute clearly gives us the ability to impose conditions. I've read the entire statute on the record. We have the ability to impose reasonable conditions that are either directly and/or incidentally related to the project requested. We have not seen any official documentation or decision or notice from anybody else saying that this condition does not apply to this application in any way, shape, or form. So I submit to you that it does apply. And I challenge anybody on this board to tell me how the fact that they are removing numerous parking spots does not create an incidental, let alone a direct relationship to the application. We have to understand that the road that is present now allows for the full and complete operation of this facility. The road that is requested is what we might call a nice to have, not a need to have. Now, I am not in any way, shape, or form in opposition to the retaining wall as proposed. And I know the applicant has gotten a lot of heat for the design of the retaining wall. I happen to think that it looks quite nice in the new renderings. The issue is the impact that that road is going to have. And as the statute says, we have the ability, and I'd say the duty, to minimize the impact by the imposition of conditions, just like we do on every other type of application. The fact of the matter is, the first day that this parking lot opens up to the school, it will be overflowing. It will be obsolete on day one. And I challenge anybody on the board to tell me otherwise. There is no ability for overflow parking. 30 spots is not sufficient at all. We've been given no data to suggest that it is, and in fact, when we've been told it is, it's been told anecdotally and by averages. Averages means some days it's more, some days it's less. And we all know by living here, they often need a lot more. The parking lot will be obsolete on day one. And what will happen is there will be no place for anybody to go because they're not building a road to accommodate on-street parking for overflow for the daily students, overflow for the parents, overflow for events, unlike they have on the current Westlake Drive. Why are we so worried to make them make up for the impact they are having on the community by building this road that they really don't need? Because we're afraid that if we impose this condition to have them put more parking and appropriate levels of parking, that they're going to have to go back to the planning board? Or keep the road where it is, they're not gonna wanna keep the road is. They're gonna say, oh, shucks, I guess we could easily build a 50 or 75-foot spot parking lot that would actually service the needs of the community and would be appropriate because of the impact they're creating by taking away the street as is. So again, I want to be clear, and I've said it before, on face value, the retaining wall, to me, is fine. The design is fine. But the impact they're creating by needing the retaining wall, because they're moving a road that they don't absolutely have to move, is something that we're not accounting for by imposing no conditions. Thank you.
You asked for it.
I wanted to allow
You
Mr.
asked
Chico
for
to
debate.
share his thoughts with us.
Oh,
I
thank
have
you.
received all his thoughts. I have nothing more to add to the conversation during our business session, and I'll defer to Ms. Novak and Mr. Dorr if they want to make additional comment.
I have nothing else to contribute on this.
So what,
We
we're
can
in
go to a
this.
vote now. We can end, come out of business session and move to a vote.
Yeah, because what we've basically done in the business sessions is just repeat what we said during the
Again,
course
Mr.
of trial.
Pacheco wanted to clarify his
And make his
position, I
record.
think,
He did.
and I wanted to afford him the opportunity to do so. That's it.
And thank you, I appreciate that.
Okay. Let's step away and go back to the meeting itself.
Make a
And
motion,
cl-
we close business session.
I close the.
I'll
meeting.
second.
All right, second. Ms. Novak?
I close the business session.
Okay. All right. We're gonna take a vote on this.
Mr. Chico, do you want to present the application with the?
I do not. I do not.
Mr. Chairman, I'll make an application at this time to approve application Z-25-14 as submitted.
I'll second.
Second by Ms. Novak. Mr. Dorr?
Aye.
Aye. Mr. DeChico?
Just to clarify, that's as submitted without any conditions, correct, Mr. Lepato?
That was my application.
Right.
Yes.
Again.
Which is
additional-
fine, I just want to be clear that that's your, I'm sorry, I didn't mean to cut you off. That's your application, right? As is?
Yes.
I vote no.
Okay. The chairman votes yes. All right, it's carried 4-1.
Mr. Chairman, I make a motion, we close the meeting.
I'll second.
All right, all those in favor?
Aye.
Aye. Meeting is now closed.